welcome to Stoughton Politics with this guy. I'm very pleased today to be introducing and interviewing Djuna Perkins, who is running for district attorney here in Norfolk County. So thank you so much for being here. And could you start us off with a little bit about your background, even though I'm sure you've been asked that enough times that you're like bored of your own life story by now. Nonetheless, who are you?
Sure. So my name is Djuna Perkins. A lot of people wonder about my name. I like to say that the D in my name is silent, but I am not. I was named after a writer who was active in the 1920s. She was American. Her parents just made it up. And my father was a writer, and he liked the author and the name, and so that's how I got it. And I was born in 1968, and this is what happens. Anyway, so for 32 years, I have, as a lawyer, I have helped hundreds of families all over Massachusetts get through some of the worst days of their lives. First, as a prosecutor for 10 years, I was in the Attorney General's office in the Safe Neighborhood, under Scott Harshbarger, in the Safe Neighborhood Initiative, in Brockton District Court, in the Appeals Unit, and in the Narcotics and Special Investigations Unit. And after that, I went to the Suffolk County District Attorney's Office, where Ralph Martin was the district attorney, and I was in the domestic violence unit there. And in my last role there, I was the chief of the domestic violence unit, which meant I had oversight of all domestic violence cases in Suffolk County short of murder. And then when I left that, I also was the supervisor of the Dorchester District Court, and I was also involved in implementing a grant project that resulted in the Dorchester Domestic Violence Court. When I left there, I spent 10 years at a small firm in Boston representing crime victims in third-party litigation against institutions like the Catholic Church, colleges, camps, and other institutions, really revolving around childhood sexual abuse and discrimination and sexual harassment. During that time, I also represented the family of the victim of alleged Craigslist killer, Philip Markoff. And I also wrote an amicus brief to the Supreme Judicial Court about that helped preserve an important evidence rule in sexual assault cases. And then in 2012, I started my own practice where I focus on investigating misconduct and discrimination for schools and workplaces. So I've done over 150 investigations for schools, colleges, high schools, colleges, private schools, public schools, municipalities, police departments, for internal discipline. And so because of that, I've essentially spent my entire career working on the same kinds of crimes, or events, just in different settings, crimes that really cause the worst harm that you can imagine, and it comes from some of the worst behavior imaginable. Yeah. So that's a little bit. I'm from New York originally. I was born in New York, grew up in upstate New York. Came to Massachusetts like so many of us when I was 17 for college. I was lucky enough to get a 100% financial aid scholarship to Smith and to Smith College in Northampton. And then I went to BU for law school. And that was where I got the prosecution bug, because Ralph Martin, I got an internship at the U.S. Attorney's Office, and Ralph Martin was then an assistant U.S. attorney, and he was assigned to investigate the conduct of the Boston police in the wake of the Carol DeMady Stewart murder. So that was a really... I had read Common Ground in college, and I knew what a watershed moment that was in the life of the city. And that's also kind of when I became a Bostonian. That was, committed me to being here.
There's so many follow-up questions I could ask to that. Like a couple of which I had prepared, but I think I might skip ahead and ask about what it's been like in the current climate and recent in the last 8 years or so. There's such an overwhelming feeling that the side of the abuser has won, and that nothing from criminal justice to politics, that nothing can protect the community from sexual abuse, and that those who come forward are as likely to be beaten down, harassed, have creepy messages sent to their doors, and so on, as they are to have any positive impact. What has it been like to work with people who are maybe committed and maybe not so committed to seeking justice in that kind of a climate?
I mean, I do think there's been progress. I think really, as somebody who started out in 25 years ago, there definitely has been a shift in what we would see on juries at the time that when I started to now. I think that people are a lot more educated about what consent really is or should be, and whether or not children are sexual beings, which is ridiculous. So I do think there's a big cultural shift. I think that human beings there will always be an element of humanity that has some evil in it. And it's not always about the outcome as much as it is about the process, being constantly willing to call out behavior for what it is and to seek the truth. The truth is the one solid thing that we can all kind of focus around on. And that is the most important thing. Even if you don't, I think that people, even if you don't get a successful legal outcome, people who are able to speak their truth, whether it's in a courtroom or in a book or to a journalist, I think each of those stories is incredibly important, and all of those things help change the culture of our society.
Thanks so much. That's I like that answer. I was curious whether you're familiar with the work of Nicole Badera, who's okay. So I've been trying to find her book and read it for some time. It's called On the Wrong Side, and it's about how colleges and universities have sometimes benefited from even from accusations of sexual assault against professors and so on. Mm-hmm. That having this culture of sexual harassment and of investigating the people who make accusations rather than people who are accused has actually been of financial benefit to colleges and universities. And it's like, I desperately want to read her book. I haven't bought it yet. I haven't found it in a bookstore yet. I know I could probably order it on Amazon, but I don't want to because I don't like Amazon. So it's like, I was just curious whether you'd.
No, I really hope that's not the case. But
right?
Yeah.
Okay. So back to a different question on your background, because you said you went to Smith College.
Yes.
And the fact that you got a free ride there is a big deal. I'm sure had a lot to do with you're interested in going there in particular. But since society both here and in the UK are in uproar right now about sort of the sanctity of gender segregated spaces, I'm interested in your take on what it was like to go to Smith College, and how much of what you liked about Smith was about the lack of male students, and how happy are you about the fact that, as far as I know, nowadays it's male or female or trans students who are like, I think you can go to Smith as either a trans woman or a trans man or non-binary. You just can't be a cis man. And how you feel about that sort of shift, and whether it's good, whether it's bad. So
wow, this didn't expect that one. So I am a Smithy, a true blue Smithy forever. It was really life-changing for me. I mean, I grew up in a family that was significantly impacted by mental health issues and substance use disorders and suicide and poverty. And so going to Smith was like, really life-changing. And I think that the most amazing thing about it was that we could be whoever we wanted to be without worrying about, what boys might be doing or thinking, or our relationships with respect to boys. For example, my one example is I was the editor-in-chief of the student newspaper during my senior year and worked on the newspaper the whole time. And it was a huge operation. It was like, I was managing a budget. I was managing a big staff. We put out the paper twice a week. We looked at all the other 12 colleges, which were kind of our peer schools, that were all of which were co-ed, or most of which were co-ed. There was not a single female editor on the masthead of any of those newspapers. And so we knew that we had something special. It was just expected. Whatever it was that you were interested, you were going to do. And there wasn't going to be this weird dynamic. And
this gender hierarchy just in your way.
Exactly. It was not going to be there. And so you didn't think about it. And I mean, it produced Smith produces leaders, and so I love it for that reason. I mean, you sort of, and the exposure. I had an internship at the Supreme Court when I was a junior in college, and that was, of course, life-changing. So yeah, for all those reasons, I think with the issue of the admissions issue, I just want. I have no problem with whoever Smith decides to admit, but I think that it's important that that it's okay for me to identify as a cis woman. That's all. Like I don't mind anybody else. I just don't want somebody to say I can't be who I am, I guess, because the whole school was created to make a safe space for women, whether they were,
at the time, presumably for cis women.
Right.
But it doesn't have to be.
Right, exactly. It doesn't have to,
Yeah.
Yeah. So I guess that's what I think.
Cool. It's just interesting because, there aren't that many, I mean, there are, but there aren't that many people who have been deeply involved in a gender segregated space for 4+ years. And when you talk to people like that, like I'm interested in sort of what that experience was like. And that makes a lot of sense. That certainly, and I'm sure to an extent it's still true, but probably not as true as it was then, that if you weren't in that kind of a space, you couldn't necessarily just step into leadership.
Right. I mean, there's a reason that Smith exists, that Smith and other women's colleges or other generation, specifically women's colleges, exist. And that is because women have been oppressed for centuries. And it was the one place where we didn't have to, not the one place, but, it was among the places that you didn't have to worry about that.
Yeah, that makes a lot of sense. I took a few classes at Smith because as a Hampshire student, I was able to do that. And I don't know why, but I found it shocking that there were male professors.
Oh, at Smith?
I was like, that's kind of weird.
Yeah.
But I'm sure there was a time where that's who professors were. And
yes, I think that's true. I mean, there was still, when I was there for my freshman year, all financial aid freshman students, their work study job was in the kitchen. And that was a throwback to sort of pre-federal financial aid when the scholarship girls had to do the kitchen work. And so it was sort of like a caste system among the students. So yeah, there's plenty of... there were definitely outdated things there. Not going to downplay that, but yes.
Okay. What, in your opinion, makes your experience the right kind of experience for a DA to have?
Mm-hmm. Well, first of all, I've had 30 years of experience working with victims of crime. And I think that is huge because the way, I have a tremendous amount of experience seeing how crime harms people. There's so many, emotionally, financially, physically, and these are effects that last forever, and or oftentimes forever. So I think that's one thing. I think another is I'm the only candidate who has had. So I'm the only candidate who's had that much experience working with victims of crime. I'm the only candidate who has extensive experience in sexual misconduct and domestic violence. And I think those are the sources of most of the worst crimes we face in Norfolk County arise out of sexual misconduct or domestic violence. If you think of all those murder-suicides we've had in the past 5 years, there's been at least 5 to 10, or probably 5 to 7 or so. And I'm the only candidate who has had line experience as a supervisor in a DA's office. And I think all of those things, well, and then beyond that, I also have a tremendous amount of life experience. I mean, as I said, both personally as a kid, and I also have, as I was talking about before, I also have 3 young adult children. I was the primary caregiver for an elderly and severely disabled parent. I've had relatives who have been defendants in serious crimes. I've had relatives who have been victims of serious crimes. So I feel like I've also represented criminal defendants from time to time. And I have a tremendous amount of experience in other areas besides the criminal justice system, which I think really informs my ability to come up with creative solutions to attack the elements in society that give rise to crime and can address it.
Interesting. Okay. what do you see as the proper relationship between the DA's office and local law enforcement?
Yeah. I like to think of it as the DA's office and the police ought to have it should be like a good friend, somebody who will have your back most of the time, but can also call you out on your crap when needed. Because it's a very delicate relationship. The DA's office doesn't supervise the police, but they have to work with them and they have to rely on them for the evidence that they present to court. But the evidence that but it's the DA who is ultimately responsible for presenting solid evidence to court that is that it was obtained ethically. Otherwise, their own license is on the line. So it can be a fraught relationship. It should be a collaborative one. Obviously, police do incredibly important and incredibly difficult work, and so do DAs. So I think each role is incredibly important and deserves respect both ways. And each needs to know how to stay in their own lane for the most part, and only intervene when it's really critical to keeping the relationship going.
So what is your approach then to police misconduct and investigations and or prosecution thereof?
Mm-hmm. So I mentioned that my first ever legal research assignment was, whether or not the Boston police could be prosecuted for their behavior in shaking down young black men in Boston after the murder of Carol Stewart. Also, in my second summer of law school, I interned at the Manhattan DA's office in the Public Integrity Division. So my job there was I was listening to wiretap tapes over and over of public officials committing misconduct. And so my approach is, if there is misconduct, it needs to be dealt with. So in terms of the Norfolk DA's office specifically, there is a state police unit that is assigned to help. They're in the same building down the hall. And I've had that experience before when I was in the AG's office. We had a state trooper unit that worked physically in the same location. That can be tricky because they're people that you're socializing with too. And so, are you really able to separate those two things? I think one thing with that unit is anyone who worked under, first of all, I think that the community has completely lost trust in the DA's office and in that state police unit.
Right.
I think that there's good signs coming out of the state police in general with Colonel Noble. And he's made some good changes, including replacing the previous commander. I think, but when I get there, one thing, so the DA doesn't hire those state police, but they can certainly say to the colonel, give me somebody else. I don't like that person. They're presenting me bad evidence or whatever it is, or I just don't like their attitude. Please send me somebody else. And so I think that anyone who worked under the previous commander, because I think there's a new one now, really I would want to ask to be replaced, even if they maybe they did nothing wrong at all. I just think the community needs that fresh, a clean slate to start with. So that's one thing. The second thing is that, we cannot tolerate evidence that is not legally obtained. We cannot tolerate discovery that is not timely produced or completely produced, because I don't want me or the people who work for me getting in trouble for what the police did. And also, it's just wrong. So I would certainly either, if it was not a conflict, certainly have no problem prosecuting it, myself within our office or referring it to somebody who would, whether that's the AG's office or another county or the feds.
Yeah. I had a question later on, but I'll bring it up now.
Sure.
About kinds of evidence, and would you use them, and are there kinds of evidence that you would categorically say, my office will not use this kind of evidence because it's based on pseudoscience or some other issue, right? Because we've had issues with certainly in this country and almost certainly in this county, with people being prosecuted based on, micro expression analysis and hair color analysis and polygraphs and all these seemingly scientific things that upon investigation do not yield good science, and are not actually usable evidence, except in court, right? Where people are still using them, and sometimes still getting convictions based on something that all our science is telling us doesn't mean anything. So are there any sort of like categories of evidence that you would say we're not using this? Like this is not meaningful, and we should not be telling a jury that it's meaningful when it's not.
So I can't. I mean, most of the examples I would think of would like polygraphs. Those are actually not accepted in court. In order to present scientific evidence to court, there's a whole process that you have to go through first to prove that this is generally scientifically accepted evidence. It's called the Daubert test, and you have to prove that, I think it's like that, not only is there a scientific basis, but also that the science is accepted in the respective peer community. And then usually there's a examination of the witness, and then the judge decides, okay, I believe, this meets the standard, and so yes, you can testify, or no, you can't. So polygraphs are one that people often talk about. People who have watched crime shows often talked about, and they're like, well, I'll take a polygraph test. We're like, well, actually, it doesn't really matter because polygraphs are kind of useless. I don't know why anybody uses them, but they're certainly not acceptable in court. DNA is one, obviously that is generally a good one.
Right.
But that's also fairly complicated, I think, depending on the kind of test and how they do it and all that. So I guess I would say the short answer is there's nothing that I can think of that comes to mind that categorically I wouldn't use, but definitely if it's not supported, if it doesn't meet those scientific tests, like if it isn't scientifically accepted in the community, then no, I would not use it.
Okay. In this era, how do you feel about prosecution for civil disobedience? Because often protesters are arrested, they're sometimes charged with crimes, and there's the question of, does the DA then prosecute, or does the DA send a signal to the police, these are not prosecutable crimes, and you can go ahead and arrest people, but they will be set free.
So, I mean, every case is different. And so one thing I think that is really tough is whenever a prosecutor, I'm always suspicious of any prosecutor who says, I will never prosecute X, I will always prosecute Y.
Okay.
Because if you say that, there's always a situation that's going to come up and make the rule look stupid. Always. So really what you have to do is look at each specific case. So let's say you take a protest and the person is truly not being violent. They're just, displaying their poster. They've got a permit. They've done all the things they're supposed to do. And then they randomly get arrested. That does not look like a prosecution to me. But if they're at this protest and they take their sign and they whack someone in the head with it, that's a crime. If they are at this protest and they are going up to people and making threatening or intimidating comments or something like that, that's a crime. So there's civil disobedience and there's expressing yourself. I think it's fine to mostly say, you can even, by the way, there's a series of, oftentimes I've seen cases where police arrest people for disorderly conduct when really what the person did was swear at the police officer. You can swear at the police officer. That's totally cool. Not cool, but because it's not nice, but I mean, it's not a crime. So there's a difference between that and saying, I'm going to kill you or your family, or, saying something like that because you believe in X, Y, Z. That is definitely a crime. I believe
you brought up, having a permit for a protest. And of course, many protests are spontaneous and are done without a permit, right?
I suppose that's true.
When was it like 8 years ago when the supposed Muslim ban of people at airports, and people were getting detained at airports, and all of a sudden people were showing up to airports and protesting there, right? That presumably they did not get permits first, and yet that was a legitimate protest, right? And a legitimate form of protest. So I guess what I'm interested in teasing out is the ways in which the legal system of saying, well, X is a crime, it is kind of providing a cop-out for prosecuting things that should be our rights, right?
Well, I mean, so let's look at your airport example. So a group of people spontaneously start protesting in the airport. I think it's fine I would not say that is a crime unless it interfere, because disorderly conduct basically is interfering with other people's rights to do stuff. So if you're in a space that isn't interfering with people's access to like the security gate or the bathroom or whatever, or you're not interfering with the business of the airport, I think that's fine. That isn't disorderly conduct. But let's say even if you say that it did interfere with some aspect of the airport, and so the person gets arrested for disorderly conduct.
You're blocking a bridge.
You're right, exactly. Those
marching
people.
Across the highway,
those people. I mean, so there's a couple things. When you, as a prosecutor, when you look at that case, you're saying, okay, does this person have a record? What exactly did they do, and how bad was it? What is the typical offense? What is the typical penalty for disorderly conduct? And does that work here? Do we think that in these circumstances, it's not really? First of all, disorderly conduct is not really that big of a crime, so it's kind of considered a minor crime, and that is where most of this would fall into if it wasn't violent or threatening or anything like that. Most protest cases would fall into there. A lot of those cases get dismissed anyway on payment of a fine. They're fairly minor crimes. So you have that discretion to look at all the circumstances and say, okay, this one wasn't, this one wasn't really.
I think I've heard of DAs, in some locations who have said, I will not prosecute disorderly conduct, right? Mm. If it's combined with some other more meaningful crime, then sure, I'll give it a look. Mm-hmm. But disorderly conduct is just not a thing I will prosecute because, standing on its own, it means nothing aside from you've inconvenienced me and I'm mad about it.
Well, it depends on who you inconvenience. Like, let's say it's a store owner, and that makes a small business owner who makes his livelihood selling stuff in their store, right? And the protest is happening in front of their store all day long, so people can't come in and buy from them. And,
But it's not a protest of their store.
Correct. I mean, it's not fair. I mean, it's not fair to them. And let's say they get upset, they lose business. Even if it is a protest of their store, I'm not sure. Yeah, you have to, the point is that you have to weigh all of the factors. So you can't just say, I will never prosecute this.
Right.
But I can say that I would not overpunish. Overpunishing and punishing people who didn't do anything wrong are incredibly wrong. I mean. Yeah.
Well, so that brings us to the next question on that line, which is, do you think there's any valid defense for the practice of upcharging, of saying, well, because you wouldn't take the plea, we're going to hit you with a more major crime that could be potentially life-destroying, mm-hmm. As a kind of intimidation tactic to get more plea deals.
Mm-hmm. So the prosecutor has an ethical obligation not to bring any charge that they don't have a good faith basis to believe they can prove beyond a reasonable doubt. So presumably, an upcharge is, if you believe that you can actually prosecute it beyond a reasonable doubt, and you think that the conduct meets that highest like the conduct or the record or a combination of both justifies the higher charge, then charge it. And then if you want to plead it down for some other reason, like the person's going to save you the money, the time and energy of a trial, it's going to save the victim from testifying, then you can plead it down. So, but nobody should be charging a higher penalty if they do not believe that they have a good faith basis to prove it beyond a reasonable doubt. And that is an incredibly high standard. That is why so many cases that seem serious are not charged higher. Like sometimes people will look at a crime and like, right. How is that just this kind of crime? And the reason is because the prosecutors looked at it and said, we just don't have it. It doesn't mean I don't believe that it happened. Doesn't mean that the consequences weren't terrible, but we just don't have it. And so, that is the job of a prosecutor.
That seems to tie into, because I'm sure that a lot of viewers have been following the Karen Reed trial debacle, and I've seen questions asked of you too. Mm-hmm. Now that second trial has mm-hmm. Failed to produce a conviction, and lots of people are certain that she didn't do it. Will we investigate further? Can we get an investigation of what's really happened? And I've seen your answer of being like, well, that might just be a waste of public funds, right?
Well, I mean, the truth is, whoever you charge now, or if you were to do that and say, like, I'm going to keep going, whoever you charge is going to be able to argue that it wasn't them who did it, it was Karen Reed. And look, the government prosecuted her twice. So you have automatic reasonable doubt for that person right there. And so, yeah, doing it again, no real prosecutor would do that either. And that sucks because it's not fair to the family of John O'Keefe. And
we have the possibility of a killer who's just, gone free.
Exactly. I mean, that is incredibly unfair. And that is what points to the error of the current district attorney. And that is why the trial of Karen Reed, both of them, was such a colossal series of unbelievable errors from a prosecutor's point of view.
Yeah, a tragedy of errors rather than a comedy.
Right. It was, it's just incredible. The fact that, I mean, for one thing, as a longtime victim advocate, one thing that you are trained to do is not make false promises. And so the district attorney promised the family of John O'Keefe, I think I can get you a murder conviction out of this, and didn't. And made them go through that roller coaster of the first trial with all of the controversy that it brought and all of the international attention that brought, and they failed to meet their promise. And then they did it again and made that. So for 3 years, this poor family has been thinking, he told me that they're going to get a murder conviction, and then they're disappointed. And then what do they, that is not the job of any lawyer, much less the district attorney. The job of a lawyer is not to tell you what you want to hear. It's to tell you what you need to know. And what that family needed to know was that this is not going to be a murder conviction because there's just not enough evidence to meet the standard, the incredibly high standard of beyond a reasonable doubt.
So what do you see as the proper role for the DA vis-a-vis federal agencies like ICE and CBP? Should there be cooperation, opposition, indifference, or some mix of all three?
So I am very concerned about relationships between the state and the federal government. So the Supreme Judicial Court has said that Massachusetts law enforcement, which includes any state employee, does not help and does not hinder ICE and federal efforts. The only way ICE really comes, or immigration issues come up in criminal cases, is because ICE has the same access to local criminal records as local law enforcement does. So what they do when they want to detain somebody is they look at their criminal record to see if they have a criminal case that's pending, and they can see the next date they're going to court, and then they show up to court, and that's where they make their detention. So that's what happened in Suffolk County a few months ago when there was a man who was in the middle of his trial, a bad guy, who was being tried for forgery.
At least as far as we know.
Yeah, well, at least. Right, exactly.
Right?
An allegedly bad guy. Sorry, you're right. An allegedly bad guy who was being charged for forgery of driver's license, which sounds kind of like a minor charge, except when you knew some of the background. That's actually a great example of why you have to look carefully at the conduct that's behind the charge. But anyway, so he's in the middle of this trial, and there's a break in the trial, like just a little recess for people to go to have lunch or whatever. The guy leaves the courtroom, and ICE is there, and they take him away in the middle of the trial. And what that did was it stopped the trial from happening, and the case got dismissed. And because of that, Massachusetts never got a chance to hold this man accountable for the crime. And even if that's you might think like, that's a minor crime, but it's actually a really important governmental structural problem, because this means that if this man should get deported but comes back to the United States, comes back to Massachusetts,
he can't be prosecuted again because of the double jeopardy rules.
Right, the case was dismissed. So essentially, the federal government interfered with state sovereignty, and that is very, very concerning. I mean, in the past, and what I understand is that there aren't any official agreements between the state and the feds when they want it. They usually just pick up the phone and say like, all right, your case is more important than mine. It's a higher priority than mine. So you go first and then I'll go.
Yeah.
But apparently that's not happening anymore. I guess one thing that I will say is I will follow Massachusetts law to the letter, and I will protect the citizens of Norfolk County as best I can. I strongly believe in the Massachusetts Declaration of Rights, which is our state constitution. I definitely believe in the United States Constitution, and yeah.
How much power does a DA have to, fight back against what at least some of us would call illegal orders, right? How is there ever a possibility of prosecuting federal level law enforcement for state crimes?
Yes.
Yes. Okay.
I would think so. For state crimes, yeah. Like if a federal law enforcement officer murdered someone, yes.
But there's a whole realm, right, of kind of terrifying gray areas where federal officials can come into a state. Like right now we're seeing DC, which is not a state,
right,
under essentially foreign occupation, right, by National Guardsmen from mostly former Confederate states, with a couple of exceptions, right? And it feels very much like an occupation. And before that, we saw it in LA, right? That there's this real hunger on the federal side for occupying and treating our states and our municipalities as kind of territory to be conquered. And what can we do within?
That's the $1 million question. I mean, I like I said, this is not a situation that I think has ever occurred before at least certainly not in my lifetime. I can't think of a historic moment when it's been a similar thing. I think that all state officials are wrestling with this. There is preemption of federal law, and so I think it's something that's going to have to be dealt with on a case-by-case basis. I mean, but you're right. It is a huge question, and I think that everybody's going to be wrestling with it.
Yeah. Okay. I have asked some version of this question of every guest I've had on because I strongly believe that everybody with even a small interest in politics has at least one subject on which they will not shut up. At least one subject where you find that thing and your friends start saying, okay, stop talking to me about this thing, right? Like a rant that you want to give. You want to shake somebody and say, you're wrong about this, or else this is really important and not enough people are paying attention. Like, what is that for you?
Well, the role of the district attorney. I think that a lot of people think that if they are law-abiding, that who their district attorney is doesn't matter. And that they could not be more wrong for a bunch of reasons. First of all, the reason that you're so safe is because of, in large part, of who your district attorney is, who your police officers are, and who your neighbors are, and, whether or not they'll commit crime. But the decisions that the DA makes and the power that the district attorney has is tremendous. And even if you don't live in Norfolk County, you probably come to Norfolk County, and you probably have friends who live in Norfolk County. And by the way, crimes are prosecuted where they occur. So if something happens to you in Norfolk County, even if you don't live here, you're going to be coming to Norfolk County. And also, people don't know what the borders of the counties are. So if they have lost faith in one aspect of local government, which, everyone in Massachusetts knows about the Karen Reed case and the Sandra Birchmore case, which we haven't even talked about. Most people know about those cases, don't necessarily know they came from Norfolk County. So if they're thinking the government is really messed up, that taint from Norfolk County goes everywhere. And people lose faith in the institutions of government. And that is really dangerous for all aspects of local government. And now is the time, as you mentioned, that our local government institutions really need to be strong and we really need to stick together and make sure that we are giving ourselves justice and due process and holding people accountable for their behavior. So that is my, and I get really frustrated with people who say, well, I'm really focused on the federal issues right now because I want to scream and say, like, but this is what's going to protect you. What is here, what we do for each other right now, right here, is the most important.
Yeah. I mean, that speaks to me a lot, especially as somebody who has recently gotten into very local level politics, right? That to some extent, what happens here is the most immediate part of your life, the things that will affect you the most in many ways. And also, they're the things you can affect the most, right? Because much though I wish I could, I can't make huge change in Washington, D.C. right now.
Right.
And so there's a lot to be said for also affecting what you can affect.
Right. And this is a problem we can change. Like there's just no question. But I also just wanted to say something about the power of the district attorney. So a lot of people also don't realize that, like, you can't sue the district attorney. If the district attorney decides to charge you with a crime, you're stuck with it. You have to defend yourself. You have to, there's nothing you can do about it. They have absolute immunity from suit. So they can decide not to charge a crime that you think really should be charged, and you have to live with that. And you have, and the opposite is true too. The district attorney can easily ruin your life. And so it's incredibly important that the person that you pick to be the district attorney is someone you feel like you can trust and to make the right decisions. And
at least 9 times out of 10.
Well, because there's also so many times that the district attorney can't be fully transparent about why certain decisions are made for the protection of the cases and the people involved. So that's it. So it makes the trust piece all of the more important. You have to trust that in those moments that I can't tell you what's going on, I really do have your back, and I really am making the right decision, and I'm looking at all of the different things together, not just one thing, not just ideological whatever. If anything, my ideology is people should not be harmed and people deserve justice, and no one is above the law, and you deserve justice regardless of how much money you have or how much influence you have. Yeah.
Okay, fantastic. That brings us to another question, which is that you have let's say 2.5 opponents in this race. In that,
who's the half?
in that, D.A. Morrissey is not, as far as I know, announced whether he is running or not. So he's the half. How have you interacted with your opponents? What makes you feel like, I should stay in this race. I am the correct choice among the 3.5 of us.
Well, first of all, I haven't seen any of the other candidates. So I announced about a year ago, September 17th, I think. And I have been going to dozens of events all around the county, all 27 towns, and trying to meet as many of the 730,000 residents that there are. In fact, this little pin is Norfolk County.
Yeah, there we are.
Which I wear to remind myself that we are a big county. We are not just one city. We are not just Quincy. We are not, which, I think that candidate that you mentioned may think is the case. But we are a really geographically and we are diverse in all ways. Every community is different and has its own unique needs and deserves to be listened to and included. Anyway, but I'm rambling now. So I haven't seen any of them anywhere in all of these events that I have seen, except I saw the district attorney at the Quincy City Caucus, and where he was, and I went to speak.
Interesting. Would you be open to like a candidate forum, or even short of that, a candidate hangout?
Interesting. Oh, but I didn't answer the second piece of your question, is why me instead of
yes.
I think it's because the district attorney the current district attorney was never an actual prosecutor himself, and I believe. And I don't think he even practiced law for very long before he got elected to the House and then to the Senate and then became DA. And I think that that's where a lot of these problems come from. This is a real job, and you need a real professional to do this job, some with skills and heart and life experience and good judgment. So that's one thing. And of all of the candidates, as I mentioned earlier, I'm the only one with 32 years of experience working with victims of crime, the only one with significant experience and expertise in sexual misconduct and domestic violence, and the only one with supervisory experience at a line level in a DA's office. So I know this job. There are many things I don't know. I couldn't be a plumber. I couldn't be an electrician. Yeah. But this is a thing I know. And I never planned to run for office. It was not in my, it was not on my life goal plan. But I strongly believe that if you see a problem and you know that you have the skills to fix it, it's your obligation to do it. And so that's why I think I'm the best candidate.
Okay, good. And also, them's fighting words. Because you have at least one opponent. Jim Bearcat is a public defender, and so it's. I'm very interested in kind of the interplay between. I was talking to my kids about this because I explain everything to my kids, even things that people think you probably shouldn't bother explaining to children. And one of them is that there is our society often has to make the choice between what's worse, letting the guilty go free or punishing the innocent. Mm-hmm. And that to an extent, the push and pull between prosecution and defense is about, people, it's often been harder for defense attorneys to run for office than it has been for prosecutors, mm-hmm. because it's so easy to say, well, so-and-so defended this horrible, criminal. Mm-hmm. And yet it's not so easy to say, for whatever reason, so-and-so prosecuted this innocent person, mm-hmm. right? And so I'm very interested in sort of where we fall as a society between like what is worse, mm-hmm. Harming the innocent, prosecuting people who maybe didn't do it, mm-hmm. or defending those who did do it.
So defending those who did do it is not a problem. John Adams defended, in the Boston Massacre, he defended the British soldiers who did the massacre, and he was one of the first amazing regular general practitioner lawyers in Massachusetts. But first of all, I'm gonna just go back for a second. Tim Cruz in Plymouth County was a defense attorney. I used to have cases with him in Brockton District Court. So he is maybe an exception to your rule. But he's been district attorney for quite some time now. So I don't think that is always the case. I think that as a lawyer, your allegiance is to the process, because there's always going to be times, the outcome doesn't necessarily mean the real truth.
Right.
The outcome is what you got with the evidence that you had and whatever the skill set you had. You hope that it's some measure of you hope that most of the time it comes out the way it should, but it isn't a perfect system because people are not perfect and people run the system. So I think that it is worse to prosecute someone who didn't do it rather than to let the innocent go free, and because we have to, because at least if the outcome,
rather than let the guilty go free.
Yes, sorry. If the process. We have to protect the process because we can't we can't guarantee any particular outcomes. But if we protect the process, then the outcomes are more likely to be accurate and just than they would be if the process was flawed. And because if you prosecute the wrong person or if you over prosecute the right person, you lose the community's trust. Once you lose the community's trust, you have no more government. This whole illusion that we have about the government, we all just kind of agreed to it. We all just said, all right, if you protect me from crime and you pave my streets and, you keep the lights on, then I will give you some money and I will let
Which is another illusion that we've agreed upon.
Yeah. This is just all a gentleman's agreement. And once a majority of us say like, yeah, this is not good, then it all falls apart. And then where are we? So, which is why all these, unspoken cultural customs that we have, like do unto others as you would have others, these are all incredibly important to keeping the fabric of society, together and going. So, yeah. that's my.
And I do want to say, we're living in a time when we have seen over and over and over again what it is like to hire people for important jobs who have no relevant experience,
Right.
and may or may not even believe in the job as a thing that should exist or as a thing that should work the way it does. And so, we have, as a society, tested time and time again the assertion that experience in a job doesn't really matter when it's a job that can be voted for. And I'm happy to see someone say, yeah, no, my experience is relevant. And it does make a difference whether this is a job you're familiar with or if it's something that you're going to pick up on the fly.
Yeah.
With here and there, there are lots of exceptions where I see people who have been, maybe in the job of congressperson or whatever for a long, long time, who may or may not be the best person for the job because the job is itself a kind of representation. And when you're representing others, as the DA does to an extent do, but when you're representing others, the question of whether you're good at it is more a question of whether you're representing a group that may be changing over time than it is about whether you are good at legislating, right? But with things like district attorney, there's both sides of it because you do want to represent the county, but you're also representing the county in a position that is extremely task oriented.
Yeah.
And where you want to be good at the task.
Yeah. It's one of the only jobs that that the requirement is you actually have to be a lawyer. I mean,
So
and that's
you
why.
have to. I can't run for district attorney. Is what I'm
Correct.
saying. Oh, well, that's a disappointment.
Right. I mean, but that's why, because it is actually a real job. But and that I think the danger of being a career politician in a job like this is that politics starts to influence your decisions about what justice is. And I think that's exactly what happened, what has happened in the past 10, I think it's 10, 12 years that District Attorney Morrissey has been in office. I think that there have been many decisions that are really shocking. So I don't know if you know this, but everyone should know this. The district attorney has this power called the null pros, and it's a Latin term, but it basically allows the district attorney to dismiss any case without having to state the reason, other than that this is in the interest of justice. And so if you were to go to the courthouses...
It's like the Supreme Court's shadow docket. It's saying, this is the thing, not doing it. No explanation.
Exactly. And no one can contest that. No one, that's just final decision because you have that ultimate authority. And you can never find out the reason why unless the district attorney just decides to tell you. So I think that there are a lot of things that one could find in the courthouses around Norfolk County that have been null pros that maybe are questionable. And I mean, there was one a few months ago that got me started thinking about this. In Dover, there was an elected the Dover member of the Dover Select Board. He might even have been the chair. Was charged with illegal or failure to properly secure firearms,
right,
and also intimidation of a witness because he told the police officer he got angry, that he could have her job for not investigating his stolen car better. Anyway, but so his car in which these guns was found. The guns were never found. So there's these two guns floating around in the universe, available for some bad guy.
A Chekhov's gun, if you will.
Exactly. And the case was null prossed. And in the null pros, apparently, the document said, based on an agreement with the Dover Select Board, the district attorney doesn't think this prosecution's in the interest of justice. I'm like, wait, what? And then later that day, he resigns from the Select Board. Okay, the rest of us could not resolve our criminal cases by resigning from our jobs.
Right.
Like how, what?
These are unrelated things.
Yes. So I have, and then the fail. I have no idea where this comes from, but the failure to investigate and prosecute or why this happened, but the failure to investigate and prosecute the murder of Sandra Birchmore is just beyond the pale. And that's in fact the case that really tipped me over and made me decide to run, because when I saw in the newspaper what everybody else was seeing about the evidence that was available, and then especially when the feds indicted the guy who was believed to be, who they believe murdered her, it is shocking. It's like literally not doing the job. And that we cannot stand for that as a community.
Potentially it's not doing the job because you have a certain relationship with local law enforcement, right?
Right. Right. Because but it's like, if we can't protect someone like that, a vulnerable young woman, what are we doing? Then we really don't have a government. We don't have a district attorney. So yeah, it's just so wrong.
Yeah. I did my best to do my homework, and I watched an interview that you did with the Young Jerks, which I'd never seen before, didn't know existed. And you spoke about the fact that even though that was an incredible miscarriage of justice, that you're not sure if the Norfolk County DA's resources are something that we should be spending on further investigating it, considering that the feds are already involved. Could you talk about that a little more?
Right. So the feds indicted the man on charges that are not murder, but they're related to the murder. I think the charge is something like killing a witness, because but it's sort of a circuitous theory, which is why it says to me, this would not have been prosecuted if we, Norfolk County, had prosecuted him for murder. The feds would not have gotten involved. But it is
bizarre to begin with that killing a witness is a different, like I could see it being as like an add-on crime that you put on top of a murder charge or manslaughter charge or something. Right. But like it's a thing of its own.
Right. And it carries with it the death penalty. Oh. So the feds have the ultimate card. And so assuming, if they are able to get a conviction, whether they use the death penalty or not is a different question, but there's no practical point in the county also doing a murder if he's already sentenced to the ultimate penalty, whether it's death penalty or life, because the ultimate penalty for murder in Massachusetts is life without parole. Right. So if you're already getting that, why put the family through that again? I mean, it's definitely worth a conversation with the family, but most families would just want to put it away. Yeah.
Okay. That makes a lot of sense. Yeah. Thank you so much. And also, oh my goodness, we're out of time with 1 second left. So thank you so much.
My pleasure. Thanks so much for having me.
And Djuna Perkins, everybody. Hi. Okay. Thanks so much.
Thank you.
Come on, sugar. Come on.